Hi, and welcome to Hull and Hull TV. I'm Dana O'Brien, and I'm joined by founding partner Ian Hull and managing partner Suzana Popovic-Montag at Hull and Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, we've been talking about the roles and responsibilities of an executor. For someone who's been chosen as an executor, how do they go about getting information and advice on what they're supposed to do?
Well, I think the best place to start is just to go to the individual who's passed away advisors. And I work with accountants, I work with insurance agents, I work with lawyers, I will work with any medical caregivers who may have access to lists or information that might have been something that the deceased has left behind and was not completely organized to let everyone know where it was, what top drawer. But the classic search in the top drawer gets you a long way as well in the bedroom. So, but always go to the advisors. They are most likely going to be the best source of efficient access to information and disclosure of assets.
Suzana, once funeral arrangements have been made, what's the executor's next responsibility?
The next thing that they'll turn to do then is to determine and collect in the assets of the estate, determine and pay all of the liabilities that have been incurred by the individual during their lifetime or debts that have been made. And then with the assistance of an accountant in many cases, they'll create a detailed inventory and a distribution plan in terms of how they're going to ultimately administer the estate.
In record keeping, debts and expenses, what's next?
Well, I think one of the early steps that a lot of executors want to make sure they've canvassed carefully is what debts are out there, what creditors are out there. And an easy way to do that from just a pure liability standpoint is to advertise locally in a paper 3 times. The Trustee Act accords certain protections after you've done that advertising. So that's a starting point. There are often creditors that are not necessarily secured or are not on the books, but they will often be hovering around after someone has passed away to make sure that their debt is top of mind with the executors. Those kinds of search, though, need to be done early because the beneficiary's expectations have to be controlled. And if there are significant debts, the net number is what matters to them, and the sooner you tell the beneficiaries about the nature and extent of the creditors, the better off you're going to be.
And is there a time limit for creditors to come forward?
Typically, it's 2 years from the date of death that they're going to have to move. Some of the rules get a little tighter than that, but that's a general rule.
Suzana, at what point does the executor distribute the assets of the will, and how is this done?
Well, typically there's what we call an executor's year. So the executor's got a year to sort of get their feet on the ground, make sure that they have determined all the assets, they have advertised for creditors, tried to determine all the liabilities. And then many times with the assistance of an accountant, they'll create a distribution plan. And so if there's specific bequests or gifts in the will of fixed amounts, those might be paid out sooner rather than later. And then with a distribution schedule that will anticipate legal fees, accounting fees, income taxes, then they can get a sense for whether or not they're in a position to make an interim distribution or possibly even a final distribution.
Ian, what happens if a beneficiary isn't happy with the division of assets?
Well, first of all, an executor is personally liable. And so we've talked about in other podcasts and also in Hull and Hull TV, we emphasize that personal liability is a vital element of any choice of an executor. So when I look at the beneficiaries that might not be happy, that claim is a personal claim against that executor. The other part, though, is that I like to make sure that there's sufficient holdback before I distribute to make sure that I've got covered off I'm ready for any fights if I can see one coming down the pipe, or I'm ready to pay any unknown tax liabilities before the final clearance certificate is issued and those kinds of things. So if a beneficiary is not happy, I need to be ready for that personal and sometimes complex claim that can be made against me.
Ian and Suzana, thank you. And thanks for joining us on Hull and Hull TV.